SJC-10487, Nickerson versus Fleet National Bank.
Good morning, Ms. McChesney.
Good morning, Your Honor. Happy New Year to the panel, and I want to thank you guys for having us be the first case out in 2010. My name is Elaine McChesney. With me today is Laura Langley. We are representing Fleet National Bank, now Bank of America by way of merger. The bank was the trustee of a family trust that was created originally in 1982. It held not only certain assets by way of funds, but also as a result of the grantor's death in 1983, became the trustee of certain real estate. The real estate at that time...
And the lessor.
Excuse me?
The lessor.
And the lessor, yes. And the real estate at that time was subject to two leases. The leases were running to the lessee of T.W. Nickerson, Inc., the corporation. In 1993, the corporation was purchased by a Stephen Clark, who was a cousin, a relative of the remainder beneficiaries and the life beneficiary of the trust.
Do you agree that the bank violated the terms of the trust when it distributed the assets?
Absolutely not, Your Honor.
Okay.
When it distributed the assets immediately after the testator's death?
Right.
What happened immediately after the testator's death is that...
No, we know the facts, but so your answer to Justice Cordy is they didn't violate the terms of the trust. Were they obligated under the terms of the trust to make the distribution?
Yes, they were.
Where do you find that? I've looked at the trust. It seems to me they were supposed to create other trusts.
Under the terms of the trust, it said that they would create other trusts. However, with respect to the trust at Addendum D12, Part 4th of the trust agreement says distribution of small shares. And it plainly gives the bank, as trustee, complete discretion if in its judgment, and that's the word, in its judgment, the shares of any of the beneficiaries, including the remainder beneficiaries, are so small that it would be uneconomical to maintain the trust.
And you say that these Parcel 5 and Lot B are is so small that in value that the bank could rely on that provision?
Yes, Your Honor. Absolutely. The purchase price that they were talking about at that time was $300,000. There were 4 remainder beneficiaries. That would render the value of these parcels or the individual trust for each of these 4 individuals less than $100,000 each. And it would, in fact, at that point be uneconomical to maintain that trust.
Well, apart from the trust, I mean, wouldn't there be a violation of the covenant of good faith under the lease anyway, if the bank didn't give notice of the offer to purchase?
No, Your Honor. The only act that is alleged to have given rise to this violation of the covenant is the bank's distribution of the trust property. And in fact, there was no violation, as the trial court found. That was a finding of fact. She was very clear in both of her orders that there was no violation with respect to this.
But I mean, that's a finding of fact, but it's based on an interpretation of the trust. I mean, so you go back to the document. Let me ask you.
I'm going to disagree with you. I don't think it was based on an interpretation of the trust because, with all due respect, the plaintiff never really articulated this argument below, that it was the violation of the trust that led to or was the reason for the violation of the covenant of good faith and fair dealing.
But the trial judge found, I believe, and you can correct me, and found that the bank decided to terminate the trust, and that, at least I inferred, or I thought she inferred, that that was permissible under the trust agreement.
She found that the bank did decide to terminate the trust, and that was permissible. But at the trial, what the plaintiff was alleging was generally other acts in violation of the trust. In fact, what the trial judge said is it was the beneficiaries at trial who kind of raised an issue about the trust. She didn't say that it was the plaintiff who raised the issue about the trust.
I understood that you were, from your brief, that you were contending that nobody had argued below that the trust had been violated, and that the important thing is that the trust was terminated, and what flowed from that termination was, at least based upon the restatement, you can't deal. The bank was not in a position to do anything with respect to that property except wind down the trust and transfer the property to the beneficiaries.
Absolutely, Your Honor. At the time of the life beneficiary's death, at that point, the trustee became a trustee in wind-down mode. And they had the trustee had very limited rights and obligations as to what it could do. Certainly, it could not sell the property outright. It could not continue to lease the property. And what it did promptly was notify everyone, I am now a trustee in wind-down mode. My powers
Did it
are limited.
notify Mr. Clark?
Yes, absolutely.
Where or when?
Unrefutably, he was notified
By the trustee, not by the beneficiaries.
by the trustee. His attorney was notified on May 29, I believe it was, in a letter in which the attorney, Mr. DeVerge, for the bank said, we are no longer, I think it's exhibit, let me find it, 95, I believe. But absolutely did say, and we've cited it in our brief and we have quoted it, that the trust is now due to wind down, and you have to deal directly with the beneficiaries.
It's in the brief.
It's in the brief, yes it is.
Now,
Ms. Mitch- go
why
ahead.
was it not a breach of the covenant of good faith and fair dealing for Fleet when it still held title to the property and learned that there was a purchase and sale agreement, not to notify Mr. Clark that under the lease, his right to a first refusal had been triggered?
Number one, legally speaking, there was no duty. There was no duty whatsoever by Fleet to so notify Mr. Clark. Number two.
I say, why is there no duty? It held the lease as trustee
Yes,
at that time, and the lease provided that when there was to be an offer to sell, that Clark had first dibs.
number one, Fleet never intended to sell the property to the Bridgewaters. In order to have any obligation.
But it knew that it was transferring the property to the beneficiaries who were going then to sell the property. So it knew the property was to be sold to Bridgewater, and it transferred the property to the Bridgewater. It winded down the trust so that the beneficiaries would hold title to the property, and it knew that they were then about to transfer property because they had a P&S.
With all due respect, I think it did not know that. And in fact, the trial court expressly found at addendum C9, Fleet fully expected that the property would be sold to the plaintiffs by the Nickersons. And what happened is Fleet notified the beneficiaries that the property was still subject to the right of first refusal, even though it knew that there was a P&S. Fleet was telling and instructing, and in fact, plaintiff alleges in its second amended complaint that Fleet instructed the beneficiaries that the right of first refusal was still in effect. Knowing that, Fleet had complied with any obligation that it had, and in fact, I would submit Fleet did not have an obligation to the plaintiff to notify it. Fleet only had an obligation to the plaintiff to notify it if it, in fact, as trustee, intended to sell the property, which it did not. The right of first refusal doesn't obligate Fleet to sell the property. And Fleet loudly, consistently told everyone, including the plaintiff, it would not sell the property, that the property would be distributed according to the terms of the trust.
Okay, but you still had the June 29th letter from Edmund to Fleet saying, Fleet, it's your job to handle the Clark issues.
That's what he was saying on June 29. However, in May, he was negotiating directly with the plaintiff himself, had reached a deal where he said to the plaintiff, I'll sell it to you as is for $200,000. The plaintiff, in fact, in late May and early June, was sending letters to the title examiner saying, we are now expecting to get a P&S signed and get a deed from the heirs of the of Lillian directly.
You don't think that because it was still a seller when the company's lawyer wrote Fleet, I think on June 25th, that it had any obligation to respond?
No, I do not think that it did.
Because?
Because at that point, Fleet had already notified the plaintiff.
Is Exhibit 95 in the appendix, or where is it?
Let me,
Very end of the appendix?
and Exhibit 95 is May 23. And in that letter, Fleet plainly tells the attorney for the plaintiff that the trust has terminated. And in fact, the plaintiff already knew this because the plaintiff had had discussions in early May at Lillian's memorial service and immediately after her death with at least 2 of the beneficiaries, in which the beneficiaries say, we are going to sell this to you directly. We're just waiting for the deed to come from the trustee. Everyone at this point, including the plaintiff, knew that the trust was in a mode of wind down. And at that point, when the plaintiff's lawyer sent the letter to Fleet, the plaintiff personally had already had discussions with Edmund, with Kenneth, personally knew about the P&S, had had discussions with the Bridgewaters, and knew that the sale was going to be consummated from the heirs, from the beneficiary to the Bridgewaters, and not from Fleet.
Ms. McChesney, can I just ask you this? In its reply brief, the plaintiff says that, assuming that Fleet acted as a disinterested trustee, that the disinterested acts as trustee are acts in trade or commerce under 93A, and the argument is that you conceded this issue at trial.
No, Your Honor. At trial, all that was conceded was that the lease between Fleet and the plaintiff was an act that could be in trade or commerce. No one made a finding that the so-called violation of the trust agreement was an act in trade or commerce. That wasn't before the trial court. That was solely something that the appeals court came up with.
Well, didn't the trial judge in the motion for reconsideration say that Fleet conceded that? Or
The trial judge said Fleet conceded, but at that point, all that the issue was whether the lease between the plaintiff and Fleet as trustee was an act in trade or commerce, and we're not disputing that. I mean, clearly, the lease was.
Okay.
What we're saying is you can't bootstrap the purely private winding up of a trust, the trustee's purely private transactions, which are only between it and the beneficiaries, clearly not in trade and commerce, and bootstrap that into a 93A violation.
Ms. McChesney, if I could ask you one other factual question. I took from your brief, and I'm looking at page 21, that your argument about the trust was that, in fact, 3 of the 4 beneficiaries, that the reason that the small share came into being was that you took the position that 3 of the 4 beneficiaries wanted to terminate the trust, and therefore the one that was remaining for Kenneth was too small. But now you're arguing something slightly different.
No, Your Honor, I think they all fit together. The reason that I broke it out that way is because everyone below agreed that 3 of the 4 could terminate and ask for the
It could, but there's
distribution.
nothing in the record to indicate that there's any request in writing. There's a letter from Fleet saying in June to, I think, Edmund saying maybe you better sign this, but there's no indication, A, that he did, or B, that the other 2 did.
And there's no requirement that he need to.
Well, in the trust there is.
Well, I think that under trust law, clearly, if the beneficiaries and the trustee are in agreement as to a course of conduct, that a stranger to the trust should not be allowed to challenge indirectly, either under the implied covenant or by 93A, what the trustee and the beneficiaries agree. No suggestion was made here that there was any purpose longer to be served by this trust. At that point, under clear Massachusetts precedent, the trustee and the beneficiaries had the right to agree on this interpretation.
Ms. McChesney, let me just go back. I heard you say something. This was a theory that the appeals court came up with. What was the theory that you were pointing to?
It was the appeals court that said that it was the so-called violation of the trust agreement that was the 93A and the breach of the implied covenant. The only issue presented below on 93A was with respect to the lease between the plaintiff and the trustee. It wasn't presented as 93A can be based on the violation of a trust agreement by a stranger to the trust.
And that was never argued below?
That was not argued below. And, I mean, it was mentioned basically by way of background is how the whole thing about the trust came into effect, into the trial.
Thank you, Ms. McChesney.
Thank you.
Mr. Sullivan?
Good morning, Madam Chief Justice, members of the panel. The case concerns contractual lease arrangements between lessor trustee Fleet and the lessee plaintiff company.
But once the trust was terminated, during that period from April until July, the deed was conveyed, the bank really couldn't do anything vis-a-vis the property other than transfer it to the beneficiaries. And I take it that the plaintiff didn't argue anything to the contrary below.
First, I disagree that the trust was terminated.
Did you argue that below? Or did anybody argue that below?
I don't think that came up before the trial judge.
Well, it's waived.
No, that's their argument. Our argument before the trial judge was that Fleet, as lessor of the lease, breached the terms of the lease as to the option to renew and the right of first refusal, that it destroyed the plaintiff's rights under the leases.
But it was incompetent to act as to the property. It lost its authority to act.
That was not argued below by Fleet, and when it wasn't raised before the appeals court, though the appeals court approached that because we, at the trial, had pointed out that Fleet had wrongfully terminated the trust.
How can you claim that?
Because it had not created the separate trusts required to be created.
I understand your argument, but what's your standing to raise that argument?
Because what Fleet engaged in was a scheme to avoid its contractual obligations under the lease.
Why would Fleet do that? Let me ask you specifically. In your reply brief, you say for its own benefit, Fleet orchestrated the sale. What is the benefit to Fleet of orchestrating a sale?
You will see in Exhibit 72, which is mentioned by counsel for Fleet and also by myself, that at the time of Lillian's death in April of 2002, on the date of Lillian's death, Fleet expressed concern about its role with the trust property, and it suggested perhaps it should take preemptive action. On the day after Lillian's death, the same person from Fleet, Rulin, who was a vice president of the bank, and I think trust officer, informs the bank that the settlor's wife has now died. The trust was now to be distributed, but only 3/4 of it can be distributed because the 1/4 for Kenneth cannot be distributed. And on this issue of the 1/4, Fleet should resign. That 1/4 means that Fleet cannot transfer the land to the beneficiaries.
But those are all disputes as between the trust and the beneficiaries.
But that was Fleet's concern, because Fleet was concerned
That
about
may
the
be,
property.
that may be Fleet's concern as a trustee,
Exactly.
right? But what's its own benefit? I mean, if I'm acting as a trustee and I, and the surviving beneficiary, life beneficiary, the spouse, has died, and a trust instrument tells me to do something, right? I mean, you can have conversations about what your obligations are, but that's as between the trustee and the beneficiary. I mean, that goes back to Justice Spina's question. What authority did Fleet have at that time to sell the property? Let's assume that the property, that the trustee, that the beneficiaries, forgive me, that the three of the four children knew nothing about the sale, that there was a third party that made an offer for whatever reason. I'm talking about past the spouse's death. I mean, Fleet's not in a position to negotiate a sale.
Fleet is the lessor, and Fleet is
No,
the
no,
owner
no,
of
we're
the
talking
property.
about Fleet as a trustee.
No, I understand, Your Honor, but I'm talking about Fleet as the lessor of the lease. The whole case is about the lease. The trial judge said the Lillian's death did not relieve Fleet of its obligations as lessor under the lease. She recognized they had specific obligations. They are the owner of the property. They are the lessor of the property. They are bound by the lease terms. It's a contractual arrangement. Fleet, when it received, if it receives an offer, just hypothetically, but actually, it was bound to notify the lessee.
Why didn't the plaintiff go after the bank for breach of contract?
The plaintiff did this as a violation of the applied covenant, because a breach of contract by itself is not what was going on here. Even Fleet has raised issues, well, did we really breach the contract because, you know, when we had the offer was then signed by the beneficiaries instructed by Fleet, and therefore, since the signed offer was between the beneficiaries who did not own the property and this third party, we couldn't be involved or sell the property. The problem with that argument, and why it's the implied covenant, is because Fleet instructs the beneficiaries to enter into the offer.
No, Fleet doesn't instruct the beneficiaries. Fleet says, I cannot do that. If you want to enter an offer, you've got to do it.
No, Fleet says it will refuse to be involved with the offer. It didn't say it can't take the offer.
Well, I mean, it's refused to be involved. I mean, how can it? As a matter of trust law, how can it?
Because
Your Honor, the trust is being distributed under, we cite the restatement of torts,
Right.
because a trust is winding down, you're still responsible for the trust. I mean, you still have to carry out your duties as the manager of the trust property. Manager of the trust property, if you're going to distribute the trust, and the trust has been trying theoretically to sell the property because the beneficiaries wanted it sold, if you're being given an offer at that time to sell the property, I think you would sell the property and reduce it to monetary value, proceeds that can then be distributed to the beneficiaries.
Well, how could that happen in this case? If they were under any obligation, it was an obligation to create 4 separate trusts.
Yes.
Probably, was all the trust property land?
There were some bonds.
Okay, well,
And the
wouldn't they,
bonds took about 30 days to be done, you know.
wouldn't they effectively have to subdivide the property and give title to 4 separate parcels to the 4 separate beneficiaries?
They would put the 4, well, if they distribute it to them, they would just have the 4 beneficiaries on the property. It's like tenants in common. They all have an interest in the same
4
property.
separate trusts.
First, you would
said-
have to create, all right.
Yeah.
It said you would create 4 separate trusts, okay, which they were supposed to do. The beneficiaries of the 4 separate trusts under the agreement could then request distribution of the trust assets. It's that distribution request that allowed Fleet then to distribute the trust property from that individual trust. That was the terms of the trust agreement. Fleet's bound by the terms of the trust agreement. Fleet did not follow that. First, Fleet did not create the 4 separate trusts. Well, if you didn't create the 4 separate trusts, then you can't have any request from the beneficiary of each individual trust for the distribution of the property. And there wasn't even a request from 3 of them, only from one, Edmund, but it's not valid because that was a request concerning the family trust, which could not be distributed. Only the distribution could occur from the 4 separate trusts that were never created, and Edmund had no right to request distribution of his trust. Edmund was the reason for the spendthrift clause in the trust. To put it kindly, Edmund was a drunk and could handle money. One of the purposes of the trust was to make sure Edmund did not get his hands on substantial sums of money because he would dissipate it. As to whether or not this money was a de minimis, I believe there's a statute, general law, it's under the probate court, 195. A small voluntary administration of a claim is considered $15,000. That's considered a de minimis claim. This, at the time of distribution, was going to be giving Edmund $100,000.
This judge in the Superior Court apparently found that the bank did not have notice of the offer sufficient to require it to communicate it to the plaintiff, to communicate to the plaintiff that the offer had been made. But then the appeals court didn't agree, it seemed to me. And the bank then claims that that's a finding, and the appeals court can't just change that finding. What's your response to that?
Well, absolutely. That was the whole purpose of my appeal to the appeals court. I claimed that the conclusions of the trial judge were based on findings that were not substantiated by the record. The appeals court went through the entire transcript, went through, God bless them, they read every exhibit, and they agreed. Some of her findings, which led to erroneous conclusions, were not supported by the record.
So they can reach their own
So they can
findings?
make their own?
When they have the entire transcript in front of them, they have all the
In
exhibits
fact,
front
a
of them.
copy of the offer was given to Mr. DeVerge, right, in
The
June?
bank's attorney received a copy of the offer, and therefore the bank received a copy of the offer. The bank was notified of the offer by the beneficiaries prior to any purchase and sale agreement being entered into. It's at that point in time that the bank starts to stray from the path, because at that point in time, when notified of the offer, rather than be involved, they're the legal owner and trustee, they tell the beneficiaries, you enter into that offer.
Mr. Sullivan, let me ask you this.
Yes, Your Honor.
In your reply brief, you say, Trustee Fleet's failure to follow the terms of the trust agreement directly impacted on the lessee's contractual rights. Okay?
Yes, Your Honor.
Let's assume that a trustee, you now have the death, which is a significant act under the terms of this trust, no question, right? Everybody understands that the spouse's death had a significant impact. And let's assume that the trustee, in good faith, assumes that it is not in a position to sell the property, right? Let's assume that the trustee, in good faith, negotiates with the surviving beneficiaries that rather than set up 4 individual trusts that are going to run up legal fees through the yin-yang, that they can go ahead and sell it. Let's assume that in each of those cases the trustee is acting in good faith and there is no claim by the beneficiary that the trustee was not acting in good faith. How can it be, under trust law, that that constitutes a violation of an implied covenant of good faith and fair dealing with respect to a third party?
With all due respect, Your Honor, the implied covenant asserted by the plaintiff in this action concerns the lessor trustee Fleet as the lessor. The implied covenant in this action is all about how Fleet acted as a lessor of the lease.
Let's assume, of course it's a lessor, but when you're acting as the lessor, I don't have any question about that, but when you have
That's
it,
the implied covenant that's violated, is between the lessor and the lessee, not dealing with the trust agreement.
well
But
then
if
how
the-
can you argue that the trustee's failure to follow the terms of the trust directly impacted on the lessee's contractual rights?
Because Fleet involved, that's part of the implied covenant. Fleet involved itself in a scheme.
You call it a scheme.
Well, I do, because you know, that's.
No,
I
no,
view-
you
I
make,
view Fleet
you
like
make,
a-
as far as I can see, unsubstantiated allegations that it was in Fleet's interest in some, I ask you about in what way was it in Fleet's interest?
Fleet has already,
Trustees make money. That's what they're in the business of doing.
Isn't the claim, isn't the, at least what the appeals court refers to, is that there was a concern about, I take it, environmental liability, and if Fleet was the direct seller, it could possibly be liable to Clark or some other purchaser, whereas if the beneficiaries were, that might not get there.
yes, Your Honor, as Fleet stated in its internal email by Ruland, the same person,
So what?
that was Fleet's concern.
But
that
so what? So what?
Because Fleet involvement with the property, in Fleet's mind, could cause it to be liable. That was Fleet's concern.
Well, that's because it's the seller.
Pardon?
That's because it's a seller. But if the trustee has the right to terminate the trust and doesn't want to take an action that might expose it as not trustee but as seller, there's no obligation that it do that, is there?
Well, there's an obligation to inform the lessee under the lease that there's an offer for the property. That was the whole problem. Fleet can do whatever it wants as the trustee, good faith or bad faith, or whatever, but it had to tell the plaintiff. It had to give plaintiff notice so the plaintiff could protect itself under its right of first refusal.
But it didn't breach the right of first refusal.
It did, Your Honor, because Fleet was
Well,
given
the
notice.
whole of the appeals court's decision rests on assuming without deciding that it did not breach the right of first refusal.
Because the appeals court concentrated on plaintiff's claim that Fleet violated the implied covenant of good faith and fair dealing.
If there had not been a breach of the right of first refusal, what is the violation of the implied covenant of good faith and fair dealing, which is that it failed to give notice under the right of first refusal?
Because Fleet, intentionally, we argue, acted in such a way to deny plaintiff its expected rights under that right of first refusal by undertaking in the offer.
Wouldn't that be a breach of the right of first refusal?
It could be a breach, but we weren't arguing a breach. We were arguing violation of the implied covenant. You don't need to have you could not breach a contract and still be in violation of the implied covenant.
I understand that, but can you be in violation of the implied covenant if what you really claim is a breach of the contract term? In other words, if you have certain rights for a right of first refusal, can you say, well, I'm not claiming a breach under that, but I'm claiming the fact that you didn't comply with your obligations under the right of first refusal is a breach of the implied covenant? In other words, the breach of the implied covenant might be a term that isn't in the contract, is nevertheless. I agree with you. There's no question about that. But can you claim that there's a breach of the implied covenant when in effect you're claiming that it's a breach of the whatever rights you had under the right of first refusal?
If I'm following this,
Think of it in another term. There's a contract term that says, I'm going to pay it on the first of every month. You don't pay on the first of every month. You say, I'm not claiming a breach of that, but I'm claiming that it was a breach of the implied covenant because you didn't pay on the first of every month.
that's a tough analogy to deal with, because in the right of first refusal, it really is, I receive an offer, I tell you about the bona fide offer. I give you notice of the bona fide offer.
And
It
if I
gives the
don't do that-
the plaintiff then has the burden of acting.
Yes, but if you don't give the person notice,
if you don't
which is
give
what
them
the
notice-
basis of your breach of an implied covenant is, it's a breach of the contract,
Well,
I think.
yes, I would say it is, but then again, as Fleet has argued in here, as a part of their scheme, they said, no, we didn't have the offer because it wasn't made to us.
I know, I
And since
understand
the
that.
offer wasn't made to us, how could we possibly get involved in responding to the offer? The problem with that argument is Fleet's the one who instructed the beneficiaries to enter into the offer so that Fleet didn't have to deal with the offer. That's part of the scheme, so that when they get the offer, it's signed by Bridgewater as the buyer, and the seller is the beneficiaries who don't own the land, which is also known by Bridgewater. Bridgewater knows the beneficiaries don't own the land. What's left out is Fleet's attorney and Bridgewater's attorney.
Hold on one second,
communicating
Mr.
about
Sullivan, your
the
time is
offer
over.
and the deed.
Justice Botsford, did you have a question?
I'm
No,
sorry.
I didn't.
Okay. Thank you, Mr. Sullivan.
Thank you.
Thank you, Your Honor.